Greetings everyone. My name is Subhiksh Vasudev and this is a short lecture on Understanding Investor-State Arbitration. It is prepared as part of the Madhyasthta-The GIADRA lecture series. In this lecture, along with my presentation, I will try to explain the fundamentals of investor-state arbitration in the most simplified manner I possibly can. The aim of the lecture is to provide a quick primer to non-lawyers, non-international arbitration lawyers, young lawyers, and most importantly, law students who have not yet been exposed to either international investment law or investment arbitration. By the end of my presentation, you should ideally have a broad understanding of the fundamentals of investor-state arbitration as a subject, one that you can use or further build on based on your respective interests. So without further ado, let's get started. Think of investor-state arbitration as a simple input-output system. Input is the request for arbitration, output is an award. Now what happens inside the system can broadly be understood through the following 6 questions. Why? Why do we even need this system of investor-state arbitration? Who? Who operates this system? How? How is it operated? What? What is this system designed for? Where? Where is the source for turning on this system? And when? When does the system become operational? We shall deal with them one at a time. Why do we even need this system? The answer is simple: for the promotion and protection of foreign direct investment. Let me explain. Goods, services, technology, capital, and even human beings are moving from one part of the world to another, all at a rapid pace. One of the most notable effects of this globalization is foreign direct investment, or FDI. Now, put simply, FDI is where a businessman in one country makes an investment in another. It could be in any sector, for example, mining, shipping, energy sector, aviation, and so on. Now, a notable feature of FDI is that it creates a link between the economies of the two countries. It creates a channel for transfer of capital and technology, international trade, and flow of goods and services. Everyone benefits in this process. The country on the receiving end, it experiences economic development, increased capital flow, creation of competitive market, increased employment, etc. Whereas the businessman on the other end benefits from global expansion, ease of doing business, tax incentives, cheaper production and labor costs, etc. Now for the ease of reference, we shall call the businessman who makes a foreign investment as the investor, whereas the country where he makes this FDI is the host state. So far so good. Now you would often hear in news about an investor being upset about how the governmental authorities in the host state are treating his investment and how this is causing or has caused him losses and damages. Now to seek compensation or any form of redressal, the investor can easily go to the state courts. But from a foreign investor's point of view, the courts are likely to be biased in favor of the government. They have every chance to be slow, probably corrupt, and will lack the technical expertise to resolve a complex case. Therefore, a need was felt in the international community to create a system where the investor and host states could settle their disputes. It is what we know today as the ISDS, or the Investor-State Dispute Settlement System. And investor-state arbitration is the most popular form of ISDS. It offers the disputing parties a neutral forum where they can appoint their own independent and impartial decision makers, or arbitrators as we call them, and where specialized procedures could be adopted for a faster decision. So we identified the cause or the need of having a system of investor-state arbitration. Now let us understand who all operate this system and how do they do it. Put simply, there are only two operators or stakeholders in this system: an investor and a host state. They are related to each other through one thing and one thing only, which is the investment. Now, to clearly and better manage their relationship in relation to this investment, the investor and the host state have three options. First is an investment treaty or an international investment agreement. Now, two countries often agree on certain terms as to how they would treat foreign investments made in their territories. These terms are clearly set out in what is known as an investment treaty. The investment treaty also defines who will qualify as an investor and what will qualify as an investment. So the end result of this transaction is that if an investor believes that his investment has not been treated as per the terms and conditions agreed in the investment treaty between the two states, and which has caused him losses, then he can sue the host state under the investment treaty. Now please note, just from the picture, it's the two states that are shaking hands while the investor is the bystander. So even though the investor is not involved in the process of negotiating the investment treaty, nor is a signatory to it, still it is his investment which is protected by it. That's the unique feature of investment arbitration. Now, most of the modern investment treaties contain provisions for investor-state arbitration, and that is how an investor sues the host state. The second option that an investor and a host state have is to sign a contract. The investor and the host state can formally set out the terms and obligations of how the investment will be treated. This is a direct legal relationship where any dispute may be settled as per the agreed procedure, including arbitration, if that's what the parties choose. And most of the times, there is an arbitration clause in the contract. The third option which is available to the investor and the host state is legislation. Now, sometimes you would see that the host state, as a matter of policy, makes a law that sets out the framework on the treatment and protection of foreign investments. So if an investor were to make an investment, that would be regulated by that law, and the investor would thus be able to assert his rights through this law only. However, it is likely that any dispute in relation to host state's treatment of a foreign investment is likely to be settled by local courts, or at best by domestic arbitration, something which an investor may or may not like. But there is a scope for investor-state arbitration. So it will be one of these three options that will determine how the system of investor-state arbitration is operated by the investor and the host state. Now let's dive inside the system and see what is it designed for. Answer: it is designed for the settlement of investment disputes between an investor and the host state. Please note that first, it must be a legal dispute, meaning some disagreement on point of law or fact or a conflict of legal views. Essentially, the position taken by one party must be objected in a serious way by the other, which unless resolved would be detrimental to the interests of one or both. And B, the dispute must be one that is related to an investment. Now, what is an investment? In investment arbitration, there is something known as a double barrel test that answers this question. Two criteria must be satisfied at the same time to show that there is indeed an investment, just like two shots are fired at the same time in a double barrel gun. Now, the investment must satisfy the following criteria. First, It must satisfy the definition under the document through which the investor and the host state are connected. Could be the treaty, the contract, or the law. And second, it must also satisfy some additional features which have essentially developed over a period of time due to the jurisprudence of arbitral awards and are meant to include commitment of capital, a certain amount of duration for which the investment should have existed, a certain risk associated with the investment that also includes the expectation of profit, to name a few. So these additional features are also required for an investment to be an investment. Lastly, let's find out where is the source for switching on this system and when does the system become operational. Now, as you would recall from the first slide, it is when the investor sends a request for arbitration that the system is set into function. Simple, right? But where does the investor get the right to send that request? The answer is the dispute settlement clause that contains a provision for arbitration. Now, to sue the host state, the investor turns to the dispute resolution clause in either the treaty or the contract or the legislation, as the case may be. Now, if that clause provides the settlement of investment disputes through international arbitration, which is most likely the case, then that clause will be our arbitration agreement. It will contain details of who can initiate an arbitration, what would be the subject matter of arbitration, where the arbitration would take place, and whether some formalities must be completed before arbitration begins. Now, who can sue would be an investor, what would be the subject matter would be an investment dispute, where the arbitration would take place, most likely the ICSID or the ICC or the an ad hoc arbitration under the UNCITRAL rules, and so on. And what could be the formalities that should be completed before arbitration begins? There could be a formality to exhaust local remedies, which means to take the case before the local courts for a certain period of time and only then pursue international arbitration. Now, all the criteria in the arbitration clause must be fulfilled. It is only then that the arbitration system can be successfully put into motion. Or in other words, it is only then that the investor and host state would have given their consent to arbitration. Please remember, consent is the cornerstone of international arbitration, and it must be unambiguous, unequivocal, and clear. So, if a person claiming to be an investor, although not being one, sues the host state under a bilateral investment treaty, then the host state will not agree to arbitrate. Similarly, if an investor under a treaty wants to sue a host state for a dispute that does not relate to an investment, then once again the host state might look away and say, I never consented to arbitrate for this dispute. However, if all the criteria under the arbitration clause are met, then consent to arbitrate would be perfected. Please remember, without consent there is no arbitration. It is fundamental to any arbitral tribunal's existence, its jurisdiction. Without the consent of both the parties, an arbitral tribunal will not have the jurisdiction to decide the case, and as a result, the final output of the investor-state arbitration system, which is the award, is likely to be set aside or not enforced. Now, I have summarized the takeaway points of this lecture for your quick reference. I would like to thank my sister Shivalika for helping me with arranging and putting up this presentation, and I hope that you also found it very useful. Thank you all for your time and patience. Stay safe and all the best.